Hello mouses, I am really under the weather today, so we're going to make this as straightforward as possible, but my head is a bit foggy, so if we go a little off I may have to issue an extra video later on to go over topics that I accidentally forgot, but we're going to do this as well as we can. Today's video is a response to a question from Marios, who writes some general queries about contemporary Anglo-Saxon jurisprudence. I've noticed that if people from countries with an Anglo-Saxon legal tradition are, uncued, asked how they feel about fairly basic concepts like innocent until proven guilty and the basics of the adversarial system, they will reflexively say that these things are all right and proper. But if they are first cued by a rape allegation, suddenly those become problematic. Starting from the position that the accused is innocent until they can be proven beyond reasonable doubt to be guilty is victim blaming, since you're implicitly stating that they are making a false accusation. Obviously this comes up because rape is an emotive issue. You can shout at someone who differs slightly from your position with a feeling of righteousness that you just wouldn't feel over a disagreement on town planning law. Suggesting that someone is, by disagreement, a rape enabler is a more powerful rhetorical claim than implying that someone is a conservatory enabler. And emotive issues tend to be more about sentiment than reason. However, when I see these debates online, I can't help but feel that it's not just this is an awesome opportunity to shout at someone while feeling righteous, but that, one, most people are really not very clear on how Anglo-Saxon legal systems work. I don't mean details, I mean fairly basic fundamentals. For example, I've just seen someone claiming that innocent until proven guilty doesn't imply anything about whether you believe the victim's testimony, because you might know that a crime was committed, but not know by whom. And two, a substantial portion of people wouldn't actually like the Anglo-Saxon legal system if they were aware of A, what those fundamentals really mean, and B, that there are many alternatives operating around the planet. I think this mostly comes up on rape debates because that's the one time people pay attention to the legal system. It feels that a lot of the criticism people have for the way rape allegations are handled are really not specific to rape allegations. However, I have to note that I'm similarly poorly informed about the Anglo-Saxon legal systems, so this might be an example of the blind criticising the blind. I guess I'm just curious which way people jump if they were made, one, aware of the fundamentals of the Anglo-Saxon jurisprudence, and two, made aware of the alternatives. Case in point, I posted this initial paragraph as an example of guilty until proven innocent. Me. After all, if someone has accused you of something, shouldn't we start from the premise that, until proven otherwise, the accuser has nothing to gain from a false accusation, and that their accusation should be taken at face value? I thought it would be obvious from content and context from the preceding paragraphs that this was a description of alternative legal tradition. However, I got this response. Someone else in the US. That's my point. Outside of the crime of rape, this is generally a given. Oh my goodness. But he goes on. From a legal point of view, only a court can determine whether a crime has occurred, said a sane-sounding person. I'm pretty sure that this is the job of law enforcement detectives, guys. Insane-sounding person. The more I see people confidently holding forth about the law when they clearly know nothing, the more I worry about whether I actually understand how the legal system works, since living under it clearly grants no automatic understanding. Okay, there's a lot to cover here, and I think he's raised some very good points. So, let's just start from the start and go through it. Okay, the principles of the Anglo-Saxon legal tradition are very interesting because, although we tend to refer to what we have now as the Anglo-Saxon legal tradition, it's actually not. It's a very English legal system. Our common law is not actually based on the Anglo-Saxon tradition. It has inspirations in it, but it's more based on the Anglo-Norman system. So let's start right at the start and explain what the differences there are. Okay, the Anglo-Saxon legal tradition comes from around the 5th to the 9th century. It develops over time, but that's during the Anglo-Saxon period. And this was really a case of trial by ordeal. The general principle back then seems to have been guilty until proven innocent because, as Marius has put as one of his points, no one really was supposed to have had a reason for bringing a false claim. So, if charges were brought and you were brought forward to a court because of local sheriffs or whatever the equivalent was, I can't remember the name off the top of my head because I am a bit ill, if they have found that you have enough evidence around you to suggest that you may be guilty, they will bring you to court. And if they've got that far, the chances of you finding yourself innocent were pretty low. So, it was trial by ordeal. If you could carry a red-hot piece of metal, I can't remember how far, it's like 6 feet or something, and then the wounds would heal on your hands within about a week or so, then you were found innocent. Similarly, if you were ducked underwater and left to drown, but you didn't, then you were found innocent. Little things like that. This is where the idea of ducking a witch comes from. That's basically the same sort of principle. Guilt until proven innocent. So, trial by ordeal is not exactly nice. But that's what they did. And then the Normans come along with the Norman conquest and 1066 and all that. And we come up with this new system. It's a common law system brought in by William the Conqueror. And his courts of assize, which would go around the area and a judge would listen to cases. The assize court would move around so that people didn't have to travel far to get justice, which is a nice idea. But the common law only recognises certain crimes. And I'm saying crimes, although at this point in time the civil and criminal laws were the same thing. If it was against the king's law, then you could bring a charge in the courts of assize. And you could then appeal to the higher courts and eventually get to the king. And the King's Bench is where that comes from, or at the moment the Queen's Bench. That's where the criminal system comes from in the courts. So, common law has writs. If you can put a writ together for a certain offence, you can bring a charge. And the problem with writs is they quickly become very calcified. So, if you can't fit the crime that someone's supposed to have committed into a writ, you can't bring a charge into the common law. That's how it goes. But that's not the only change from trial by ordeal, where we actually have a trial. Wow, that's an interesting thing. People are going to sit down and listen to evidence and then work out guilt. Oh my goodness, this sounds Roman. Because it is, basically. The Roman system is very interesting. Of course, it's the civil system that a lot of Europe uses, parts of America use, and half of what the Scottish law system uses. Very interesting, because you have a codified set of rules, and if you break those rules, a claim can be brought against you. Again, very little difference between civil and criminal, because it's all in the code. If it's codified, you can bring a case. Not so in the common law. Again, if there's a writ, you can bring a writ. So, what happens here? Well, a judge in the common law system listens to pleas on both sides. One person says this person is guilty, one person says this person is innocent. The judge sits there from a starting point of nothing happened, then you prove that a crime happened, and then they prove that they didn't do it, and then you prove that they did do it, and then they prove that they didn't do it, and it goes on like that, basically, until you've got a big adversarial system where the two lawyers, one on either side, are effectively trying to destroy each other's case in order to prove their own point. It's very adversarial, takes a lot of time, and it's not exactly great, but it does kind of work. And that's where our principle of innocent until proven guilty comes from. It's the standpoint that the judge will come in from the point of view that nothing has happened. Both parties, from his point of view, have to prove their case, effectively. But here's the important point. Because it comes from the point of view of nothing's happened, until a case has been proven, the person in the defence doesn't have to say or do anything. Because nothing's happened, therefore they must be innocent. Now that is how all of our criminal system works. This person here, the defendant, does not have to say or do a thing, because until you prove something happened and that they did it, they are innocent. That's how that is. Okay, the police may have put together a case against them, and the Crown Prosecution Service has looked over that case and decided that there's a case to answer, but the judge comes in going, show me the evidence. Prove that they did it. Prove that something happened. And prove that what they did was actually against the law. Until that point, they don't have to do anything. Fair enough, surely. That's a pretty good system. Yes. And no. Because, as was pointed out by Marius here, we have cases where people might know that a crime has been committed, but not know who did it. It might be obvious. For example, let's have a look at the Kennedy assassination. We all know he was shot and killed. We don't know who did it. We think Lee Harvey Oswald did it. We don't know for sure. Well, some people think they do, but that's beside the point. The point is, if it came to a court case, okay, we can start from the point of view that something has happened that was wrong, because we have here a dead body. But even so, the prosecution have to put forward that evidence that someone has been murdered. and then they get to state their case. So even from situations where we know a crime was committed, we just don't know by who, you still have to prove the crime was committed. That's how it works. Because I could just say, oh, that house over there has been broken into. We can see that it's been broken into because the door's been smashed down. Okay, very good. Prove that it actually happened. What's to say the owner of that house hadn't lost his keys and then broke the door down himself, and then you come along and arrest some guy that happens to be there, for example, a friend who is helping guard the house until the person comes back with a new door? How do you know that they aren't just them, rather than the person who broke in? You don't. You still have to prove that crime has been committed. So, adversarial system, everything has to be proved. There's nothing wrong with that, surely. But when it comes to a rape case, there is the charged problem of emotion. Because, oh, this person claims they've been raped. Well, that sounds bad, doesn't it? Because I've just said claims. And there's a lot of baggage that comes with a word like claim. But unfortunately, that is unavoidable. How do we get around the fact that it is a claim until it's proven one side or other? Because I can claim all kinds of things. But it doesn't mean that just because I've claimed something here which turned out to be untrue, that this over here is also untrue. We're not talking about the boy who cried wolf here. That doesn't matter. Everything has to be taken on its own merit. So, what can we get from this? I have to say, I do agree with Marius to the extent that if people knew what the alternatives to the common law system were, there would be a lot more debate, at least, on whether we're using the right system. Because we have to remember that the common law did calcify very quickly, and unless you had writs for certain specific things, you couldn't bring a case, which is where equity comes from. Equity is in all parts of the English law system now, because it helps enhance common law. And you've got to remember that also, you've got to look at criminal and civil law differently now. Because in the English legal system, criminal law is over here, civil law is over here, and they never meet. But both come from the same point of view, where the judge comes in with a blank slate, and you've got to weigh up both sides so you can tally it down and decide either way. So let's get back to the core topic here, which appears to be the problem that people think they know what the law is and what the legal system is and how it works when they really don't. Unfortunately, this is due to the way that we teach law in schools, as in we don't. The legal system is something that has been systematically removed from modern society. Effectively, it is closed off, and unless you're someone who studied it, you don't really get to see an awful lot of it, or you happen to be involved in it in some other way. For example, you happen to work for the court service, and you are one of the bailiffs, or you're the one of the people who records everything, a court reporter. You happen to be a journalist who listens in on court sessions to report, and things like that. You won't really see what's going on. And that is a big problem, because people think they know what the law is, and they don't. It's all down to education. There's not much we can do apart from produce videos like this where we try and explain things. So, is an accusation charged when it's due to rape? Yes, it is. But I would say no more than a charge of murder. Both will ruin people's lives. That's not to try and detract from the fact that rape is a horrific crime, of course, because I would never do that. But when people make arguments such as someone suggesting innocent until proven guilty makes someone a rape enabler, I have to disagree with that. That is just petty point scoring on the side of the people making the argument. Because you have to be innocent until proven guilty, otherwise we're back to the Anglo-Saxon system where you are effectively having trial by ordeal. If you can face up to the press and the gauntlet that they will put out for you and get through everything and manage to show your side to the judge, then perhaps you can get off. But if you fail at any point, then you can't. That's terrible. That's ruining someone's life just because of a misunderstanding, effectively, or even maliciousness. Because, oh, I don't like this person down the street, I'll claim that they raped me. That's not good. That does happen. We've seen mentally ill people like that make claims, and that's why the rapist has to be protected until they're proven guilty. I don't like to say that, and it sounds terrible, but at the same time, there are people out there who will make false charges, and it is unacceptable to send even one person to jail wrongly, just because the system doesn't seem right in the eyes of people who haven't studied it. And that's all I've really got to say for that. So I hope you've enjoyed this video. Remember to click the like button, share it with your friends, and subscribe for future videos. If you disagree, please do send a comment and we'll discuss this further. But until next time, I've been Kirk-Robinson, you've been watching the Knob Mouse channel, and I'll see you tomorrow.